Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to learn a case law on Consumer Protection Act regarding the commercial activity. Friends, already I told you that according to section 2 of the Consumer Protection Act, consumer is a person or entity or a company who buys the goods for personal consumption, personal use. They must have the bill. So here, whether it is personal use or commercial use, it's more important. If it is commercial use, definitely it will not attract the Consumer Protection Act and you have to go to the so-called civil court. Now, while discussing the case of, this is more important, please remember, present case, National Insurance Company versus Harsolia Motors and others. National Insurance Company versus Harsolia Motor and others in civil appeal number 5354 by 2007 on 13/4/2023, two judges bench, Honorable Justice Ajay Rastogi and C.T. Ravikumar, held that the commercial enterprise can also raise a dispute, consumer dispute. The commercial institute can also raise a consumer dispute in relation to the goods unconnected to profit generation. This is more important. Whether it is a profit-making activity or not, this should be known first. That's why I have given a classic case of Anantaraj versus Telco. Anantaraj Agencies versus Telco, 1996. So in this case, the Anantaraj Agencies, they purchased a car for the personal use of one of its directors. Personal use of one of them. So the court held that it is not for profit-making activity. No doubt, even though the defense, actually they pleaded that it is a commercial activity, the court held that it cannot be making, because the court had not, they clearly stated that it is not for the profit-making activity of the company, but it is for the personal use of the director. So therefore, it is a personal thing and definitely the case was successful. Likewise, present case, Harsolia case is also another such case. Let us go into the brief facts of the case. The case మీకు అర్థమైందనుకున్న జాగ్రత్త అండి. పర్సనలా కమర్షియలా? పర్సనల్ యాక్టివిటీ అయితేనే కన్జ్యూమర్ కింద వస్తుంది, కమర్షియల్ అయితే రాదు. కానీ కమర్షియల్ కంపెనీ తన యొక్క పర్సనల్గా తీసుకుంటే, అలాగే ప్రాఫిట్ మోటివ్ లేకుండా చేసే యాక్టివిటీస్ ఉంటాయి, అదైతే డెఫినెట్గా కన్జ్యూమర్ కేసు కిందే వస్తుంది. ప్రాఫిట్ మేకింగ్ అయితే రాదు, అదనమాట దీంట్లో చెప్పింది. రైట్. సో దీస్ పీపుల్, హర్సోలియా మోటార్స్ as well as their neighbors Rakesh Narula and others, they have insured their vehicle. That is, actually they are Tata dealers, Tata vehicle dealers. They have got a big showroom. They have covered the showroom for 75.30 lakhs, and Rakesh Narula, they have covered it for 90 lakhs. So you all know Godhra incident. It has sent shock waves across the country. So during the Godhra rise, some miscreants, they have entered, they have burnt the Tata showroom, they have damaged the entire machinery or whatever goods available in this. So therefore, they filed a case of insurance. And Rakesh Narla, he got 54.38 lakhs or so out of 90 he has got. But here the point is, they stated that it is a commercial activity, commercial organization. Therefore, there is no point. There is no point in Consumer Protection Act. They cannot be called as a consumer. This is the defense by National Insurance Company. Of course, the State Commission accepted the version of the insurance company, but NCDRC, National Commission, they rejected the same. They asked them to pay the compensation. Therefore, as against the order of the NCDRC, they have approached the Supreme Court. In matter at the Supreme Court question, National Insurance Company appeal చేసింది. సో దీంట్లో మెయిన్ పాయింట్ ఒకటే, వెదర్ ఇట్ ఈస్ ఫర్ ప్రాఫిట్ మేకింగ్ ఆర్ నాట్, ఇన్సూరెన్స్ ఎందుకు చేసుకుంటారు? కానీ ఇంకా మీకు చెప్పాలంటే ఈ కార్ల యొక్క వ్యవహారంలో కార్లు 100 కార్లు కొని వీటిలో అమ్మే వాటిలో అయితే ఈజ్ నాట్ ఎ కన్జ్యూమర్. కానీ ఇన్సూరెన్స్ ఇట్స్ నాట్ ఎ ప్రాఫిట్ మేకింగ్ యాక్టివిటీ, ఇట్స్ ఓన్లీ ఇండిమికేషన్ ప్రాసెస్. ఏదన్నా జరిగితే తనకేదన్నా నష్టం జరిగితే తిరిగి ఇచ్చేది, కాబట్టి ఇట్స్ నాట్ ఎ ప్రాఫిట్ మేకింగ్ యాక్టివిటీ. Therefore, insurance has to be paid. This is what is held by the Honorable Supreme Court. So please remember, they have actually stated that it is a benevolent, beneficial construction, liberal interpretation. Then the difference between person, service and also consumer, all these things have been explained in detail. So person includes firm, even self-employment. Already I told you, a person who purchases 3 auto rickshaws, it cannot be called a commercial activity because it is for his food. ప్రభుత్వం ఇస్తూ ఉంటుంది, జై సీఎం సార్ అని చెప్పి అప్పుడు పేపర్లో కూడా కనబడుతుంది. సో దే ఆర్ నాట్ కమర్షియల్ యాక్టివిటీస్. సో ప్లీజ్ రిమెంబర్, here is a very classic case where the commercial activity has been defined. Ultimately, the company, insurance company, is ordered to pay compensation. So very important case. Please read the case. If you don't understand, I will explain the class also. Very good case, classic case. So read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.